I mean, first of all, tongue-in-cheek, speak to an employment lawyer, a good employment lawyer. Obviously, we're always on hand. One second point is obviously, whatever you do, think about the decisions that you're making. Think carefully. Think if it's reasonable. Be objective. Challenge yourself. Make a written note of everything that you're doing. That's creating contemporaneous notes of situations that you're involved in is always key. It's always good evidence for a dispute that may arise later down. And I think that, you touched on it then, Matt, that the tribunal system, there will be an influx of tribunal claims. Already we've seen so many more claims just going through the system, and the system was backlogged before the COVID, the impact of COVID happened in March. So I think the tribunal system was at bursting point. It will continue to be at bursting point. So anything that employers are doing at the moment, whether it's keeping notes, and if that's then challenged at a later date by an employment tribunal, the likelihood is that employment tribunal claim is likely to be determined for the next 18 months, 2 years. So that's a hell of a wait for certainly an employer and an employee, if an employee feels unjustly treated with a claim, if an employer is wanting to defend that claim. And, for example, we do a lot of defence work with ARAG because of the legal expenses policy. Is a really good policy that's in place that I know certainly talking to their policy holders, they really are grateful for, because, at the end of the day, it's a fees that the insurer is going to be paying for, and our invoice will go to them, and it's something that certainly is a balanced sheet of protection from that perspective as well.